So yes. Okay. So I'm going to start with introduction to our organization, TASK. Um, to introduce our organization a little bit, TASK is a nonprofit organization, and we serve LA County, Orange County, Riverside, San Bernardino County, San Diego, and Imperial counties. And our offices were located in Brea, Alhambra, San Diego, and Riverside. Our Brea office is our main office. So yes, so those are our office locations. Um, we are a parent training information center, and we're also we are also a family empowerment center. Our mission at TASK um, is that TASK educates and empowers people with disabilities and their families. So we our work is to help families um, with students, children, and people with disabilities. And some of the services that we provide at TASK are we provide individual telephone assistance. We do one-on-one consultations. Before we did in-person consultations, but through this pandemic right now, we're doing virtual consultations as well as over the phone consultations, um, review of IP documents and evaluations. And we also provide educational virtual webinars, such as this webinar. And we also provide assistive technology over the phone, as well as virtual labs. And also our assistive technology department also provides webinars as well. Just to inform you that uh, we at TASK, um, we're family support specialists, and we're not advocates or attorneys. So we do not provide recommendations, legal advice, or suggestions. Our family support specialists, we offer peer-to-peer support, information, and options to parents of children with disabilities, so that they can become informed members of the IEP team as they, work collaboratively with the school to help your child. So as we go into this webinar, just want to inform you that the contents of this PowerPoint were developed under a grant from the Department of Education. However, those contents do not necessarily represent the policy of the Department of Education, and you should not assume endorsement by the federal government. Okay, so for our webinar today, our agenda, these are the topics we will be covering today. We're going to first talk about the early intervention program for infant and toddlers with disabilities. And then we're going to talk a little bit about Every Student Succeeds Act, the ESSA, as well as the ADA Amendment Acts of 2008, which is, or the ADAA. And then we're going to continue and talk about Section 504 of the Rehabilitation Act of 1973. And then we're going to talk about the Individuals with Disabilities Education Act of 2004. And then we're going to talk about comparison of IDEA and Section 504. And we're going to end our webinar with the topic of due process rights. So for the early intervention program for infants and toddlers with disabilities, it was initiated under the Education for Handicapped Act in 1986. And then it was reauthorized under the IDEA Part C Amendment of 2004. And this program, it assists states with funds to plan, develop, and implement programs for eligible children. It's for children's ages 0 to 3. And services for this program are provided through the Individualized Family Service Plan. So once a family or a child gets qualified under this early intervention program, each child is given an IFSP, which is an Individualized Family Service Plan. The services for the early intervention program, they're based on child needs assessed, so what the child needs, and then also family concerns, the concerns that a family might have regarding their child, and then what is the results from the IFSP developed by the IFSP team. So once, which includes the parents. Parents are the most important member of the IFSP team, and they develop the IFSP um, and the needs that are assessed there, as well as the child's needs, as well as the concerns that the family have. So based on these three things, services are provided. So in the IFSP, the Individualized Family Service Plan, some of the services that a child can receive are assistive technology, audiology, health, nursing, nutrition, occupational therapy, physical therapy, mental health services, transportation, and related costs. So that was the Early Intervention Act, and now we're going to move on to Every Student Succeeds Act, which is the ESSA. Now, this law was signed into law on December 10th, 2015. The ESSA was reauthorized the Elementary and Secondary Education Act of the 1965, as well as the No Child Left Behind, NCLB. So some of the things that the ESSA does, some of the provisions provided by the ESSA is that it ensures access to general education curriculum. It also ensures access to accommodations for assessments. It also ensures concepts of universal design for learning. And it requires school districts to provide evidence-based interventions in school. It also, the students with the most significant cognitive disabilities through this ESAA can take the alternate assessment aligned to alternate academic achievement standards. So this provision allows them to students with significant cognitive disabilities to take alternative assessments. And with the ESSA, states will also improve conditions for learning for the student and reduce overuse of discipline practices and the use of aversive behavioral interventions, such as restraints or seclusion. And states will also reduce incidents of bullying and harassment in school. Some ESSA provisions for all students is that it maintains annual statewide assessments for reading and math in grades 3rd through 8th and once in high school. So California tests in 11th grade. And it maintains annual statewide assessments for science in each grade span. So California tests for California, they test in 5th, 8th, and 10th grades. And it also helps states to improve low performing schools. Actions will be determined locally and not federally. And finally, it eliminates highly qualified criteria for teachers and paraprofessionals. Okay, so we talked about the early intervention, and then we went over also the ESAA. Now we're going to talk about the ADA Amendments Act of 2008, or the ADA. And this was signed into law on September 25th in 2008, and amended the Americans with Disability Act, or the ADA. So it amended the ADA of 1990. So the definition of a person with disability under the ADA is the same as the definition under Section 504, which is that a person with a disability is a person who has a physical or mental impairment that substantially limits one or more major life activities. So that's how the ADA and Section 504 defines a person with a disability. And the ADA also made it easier for people with disabilities to establish that they have a disability. And through the passage of the ADA, overturned Supreme Court decisions and broadened the definition of disability to include conditions such as diabetes and epilepsy. Like before, conditions such as diabetes or epilepsy, it wasn't really included, but through the passage of this ADA, conditions such as diabetes and epilepsies were able to be included. Some protections that a person can receive under the ADA are access to employment, transportation, privately owned businesses such as restaurants, stores, and hotels, state and local government facilities and programs, auxiliary aid and services for college students, such as assistive technology. So that section just covered a little bit of the early intervention, as well as the ESAA and as well as the ADA. If anyone has a question at this time, we can take some questions.
So far, there's no questions.
No question at this time?
No, but can I also mention something? Because there was one question, but it wasn't about the presentation necessarily.
Okay.
To answer, yes, if you need a copy of the PowerPoint emailed, go ahead and either send me a direct message, Diana Ruelas Ryan, or you can put it in the chat and we'll make sure that you get a copy.
So yes, Deanna will also be sharing the resources as well as the handout for the PowerPoint. There's a sheet with resources that we've collected for this presentation. So that concludes my part, and I'm going to hand over the mic now to my co-presenter, Elias, my co-presenter slash co-colleague. Here you go, Elias.
Thank you, Anna. Good evening. Elias Alvarado, Family Support Specialist, and I will continue with this presentation, beginning with Section 504 of the Rehabilitation Act of 1973. Section 504 prohibits discrimination for people with disabilities in programs conducted by federal agencies, programs receiving federal financial assistance, and the 504 is a federal civil rights law. It protects students from disability discrimination by public schools. Also, students of all ages who have a physical or mental disability that substantially limits a major life activity that can include reading, learning, and concentrating. People with disabilities, students, are qualified to receive reasonable accommodations, giving them equal access to learning and school activities. Now, the 504 program provides access to the general education program. But under the 504, there are services available to students, and those could be accommodations or modifications. Who qualifies for Section 504 of the services? Any person who has a physical or mental disability which substantially limits a major life activity, has a record of a disability, is regarded as having a disability. Next slide, please. What is a major life activity under Section 504? Caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, and breathing, learning, and working. Next slide, please. Protections under Section 504. Education. The students are protected from discrimination. Accessibility, and this is what the 504 program offers, access to the general education program. Also, it covers employment. And when a student graduates and either goes to college or employment, they don't have to inform the employer of their disability unless they need an accommodation or modification. Next slide, please. Requirements under Section 504. Evaluations, free appropriate public education known as FAPE, related services and supplemental aids and services, placement, least restricted environment, LRE, the 504 plan, and a grievance procedure. Now, the 504, their placement will be usually in a general education classroom. And it is advised that the school develop a 504 plan for the student. And of course, to develop the plan, they will have to do an evaluation. With the results, they will place in the plan the areas the student needs help in, and then the service plan to provide the services for the student to be successful. Now, both IEP and 504 have a grievance procedure. Next slide, please. Section 504, procedural safeguards, grievance procedures, the due process, the 504 coordinator, and the contact office for civil rights, U.S. Department of Education. Now, The IEP has the due process. The 504 has the 504 coordinator. If there is a dispute, they will meet with the coordinator to try to resolve. If it cannot be resolved, then the parents, if they wish, may take it up with the Civil Rights U.S. Department of Education. Protections under Section 504. Who's eligible? Most kids with learning and thinking differences are protected by Section 504. The law can cover students with learning disabilities like dyslexia and those with ADHD, anxiety, and many other challenges. Section 504 procedural safeguards, and we have already covered those. So may we proceed to the next slide? Now we are going into the Individuals with Disability Education Act of 2004. Federal law that governs special education. Signed into law December 2004 and reauthorized the idea. Brought about changes to early intervention services, the IEP process, the due process, discipline and manifestation, determination, and secondary transition. Now, the IEP process, in some states are offered, IEPs are offered every 3 years. The due process is for the IEP student. Disciplinary and manifestations, determinations will take place if a student is going to be expelled from school for a violation. It could be a weapon or drugs, something very serious. And they have to have, the school has to have a disciplinary and manifestation meeting, do an evaluation to see if perhaps the child's disability was the cause of the violation that took place. Secondary transition has many services, and parents should contact the guidance counselor or the transition counselor and find out about all the services that are available to students. Next slide, please. Rights under IDEA. Free, appropriate public education, known as FAPE, least restricted environment, related services and supplementary aids and services, fair assessments and evaluations. Now, it's important that parents know these 4 basic rights. The first one is a free, appropriate public education. So how can a parent tell if the child is receiving an appropriate education? The evaluation will provide that information. Some parents have difficulties understanding the evaluation report. So TASC does offer IEP consultations where the parent will need to have the most recent IEP document and most recent evaluation report for the consultation. The least restricted environment, some students may go into general education. Some students may go into the special day classes. Parents need to know about these special day classes. And we also provide consultation for that. Related services and supplementary aids and services. The related services are the therapies, for instance, physical therapy, speech and language, occupational, recreation, and transportation is also a related service. There's many more services available. And if parents would like a copy, they should contact their school district and ask for a list of related services and supplementary aids and services and the accommodation modifications list. It's very important that parents know these services because there needs to be parent input in the IEP meetings. And this is one way of having parent input by knowing which services are available and which services the child may need. Fair assessment. There has to be more than one assessment completed. The school district has their assessment team. And for example, the speech pathologist will do the speech and language. The special education resource will do the pre-academics and academics. And the school psychologist will do the social emotional. And there's other testing that other team members will perform. Next slide, please. Comparison of IDEA in section 504. Next slide. Similarities of IDEA and section 504. Protection against discrimination for students with disabilities. Provision of free, appropriate public education. Provision of related services, supplementary aids and services. And those are the accommodations and modifications. Requirements for education in the least restricted environment, which could be the school placement, which there's quite a few, public school, county school, charter school, non-public school, and others. And the classroom placement, again, could be the general education or one of the special day classes. Requirements for fair assessment that includes validated assessment tools that are administered by trained personnel. And that would be your assessment team from the school district. Requirements for notice of procedural safeguards. Very important. Next slide, please. Differences of IDEA and section 504. IDEA. Students must be provided with services and placement so that they can benefit from their education. Section 504, students with disabilities are provided services that are as effective as those provided to non-disabled peers. IDEA. Testing is a requirement prior to eligibility and is conducted every 3 years, known as the triennial evaluation. Section 504 does not have these requirements. Next slide, please. Home files. It is important to maintain an organized home file for your child's records. You should have 2 binders about 2 to 3 inches thick. And on one binder, you're going to place the educational history of the student. And it's good to put the annual reports the evaluation reports, copies of the IEP document, a contact list, and the contact list can be beginning with the school teacher, going up to the principal, to the special education department, to the superintendent of public schools. You may want to keep a list of those persons. And also, what I see is it would be a very good thing to work samples. It's say that the child goes into the fifth grade and you collect the work samples, the beginning of the fifth grade, and then at the end of the fifth grade, collect the work samples and compare them. Now, on the other binder, you will have your medical history, medical records, diagnosis, family history of illnesses or of any other disabilities. Now, it's important to keep these binders when the student graduates, goes to college. At college, they do have the student disabled office, and they will probably ask for this information. Now, if the student decides to seek employment, and if the person will need accommodations and modifications, they will also need to show that they have a disability. And so saving these would be very helpful. Next slide, please.
That's it.
Oh, thank you. Well, please be sure to fill out your webinar evaluation form. The survey link is there at the bottom. And if any questions do not apply to you, please write N/A for not applicable. Please do not leave it blank. Thank you for joining us this evening, and now we'll take questions.
There are some questions. So the first is, do the protections under IDEA and Section 504 continue in college?
The IDEA ends when the student leaves high school, either with a diploma or ages out. The 504 protections will continue. And then you'll have the Americans with a Disability Act also.
If I, hi, this is Paula. If I can add to what Elias is saying. So he mentioned that the 504 protections continue for a student once they leave high school. And I just want to clarify that when he gave his presentation, he did a great job of explaining that students with a 504 that are in school have educational rights, as do students who have an IEP. And those are free, appropriate public education, education in the least restrictive environment, related services, and an evaluation. So those educational rights under Section 504 end when a student leaves high school, just like the educational rights under the Individuals with Disabilities Education Act end when a student leaves high school. So the educational rights end for both laws, under both laws, but the civil rights protections for Section 504, where it gives a student equal access to college programs or to employment programs, those will continue for the duration of the person's life, as will the ADA. So I just wanted to clarify that.
So there's another question. This question reads, in regards to the 504, my son is in the 8th grade. When he was in the 6th grade, he had an IEP, but didn't qualify. He has always been behind at least 3 grades in reading. At the time of the IEP, The school didn't mention anything about a 504. Do you think that this will help him in general? He's below average in most of the areas.
Parents can request an IEP evaluation once a year. If the child is not advancing and making progress, and then the parent, again, that's why you have the binders and the one for the education history. Parents should keep track of the child's progress or no progress. And this would be good information to provide to the school district as to why the child needs an IEP. And when they do the IEP, and then the parent should, if the parent does not know, understand what the IEP evaluation is saying, TASK does offer consultations and will help you with understanding and using the evaluation results to get services for the child.
So I was wondering, so thank you, Elias. And I just want to add to that and maybe ask the person who asked the question for clarification. So the child had an IEP and then they didn't continue to have an IEP and they want to, but they didn't say anything about exiting him or transferring to a 504. Is that, maybe I misunderstood.
If I may add to that,
Yeah.
when they're going to exit a child from the IEP, they have to do an evaluation. Now, and this is for the parent, did the school district do an evaluation to exit the child out?
So to clarify, he didn't qualify for an IEP.
So
Oh.
he had a 504, right?
No,
No.
she
he
said
didn't.
that she said that they didn't mention the 504. That
Okay.
so you can correct me if I'm wrong. It sounds like he was evaluated for an IEP. He did not qualify, but they never mentioned a 504 as an option.
Okay.
Did the parent request an independent educational evaluation paid by the school district?
I'm waiting to see. She said that no further services were offered, but I'm waiting to see if she responds to your question, Elias, about the the independent evaluation. No.
So if it's been a while, I don't know how long it's been since your child was assessed and not found eligible for an IEP. If it's been less than a year, you can appeal the decision, or you can also request that the district consider eligibility under Section 504, because that eligibility is much, much more broad. They don't have to qualify under one of 14 specific categories. They can qualify if they have a physical or mental disability that substantially limits a major life activity. So if that's the case, if it's been a short period of time, then you can ask the district either to reconsider their decision and provide more substantiation that the child would qualify for special education services, or you can ask them to consider eligibility under Section 504. If it's been a while, if it's been a year or more, then you could ask the district to assess the child again, like Elias said, and then determine if the child indeed would be found eligible for special education this time, or immediately ask them to consider Section 504 eligibility if he doesn't.
Okay, great. Okay, we do have more questions, so just bear with me because I have to go up on the chat. Thank you for being patient, everybody. Okay. Do any of these laws or regulations somewhat vary during distance virtual learning because of COVID?
Do you want to take that, Elias or Anna, or do you want me to?
Would you take it, Paula?
Sure,
I didn't quite
sure.
understand the question.
Okay, sure. So yes, the Individuals with Disabilities Education Act has been, that law is still in effect. Nothing has changed about the federal law, but you know, the federal laws are implemented in each state a little bit differently. So each state has the ability to provide its own unique way of implementing the federal law, right? And so in California, on June 29th, 2020, so about six months ago, a little over 7 months ago, Senate Bill 98 was passed. And this bill impacted only for California. It's a California law. So all the federal timelines, all the federal guidance for special ed are still in place. But because Senate Bill 98 was passed in California, that impacts the amount of time that students have to, or that districts have to provide educational minutes per day. So that was changed for each of the grade spans in California, but it's only for this school, 2020 and 2021. So I think you may have noticed that your kiddos are spending less time receiving education this year. The other difference is that every child who has an IEP needs to have an emergency plan written into the IEP at least by the next annual IEP. So this law was passed in June 29th of 2020. So if it would seem that all students then by June 29th of 2021 should have had an annual IEP somewhere in there. So all those students should have an emergency plan that's written into their IEP. And the emergency plan is supposed to tell you how services are going to be provided during an emergency, what services are going to be provided, and if they're going to be provided in a different way, what is that going to look like? And then also what a transition service is going to look like for students who are age 16 or older.
We have more questions. Let me make sure that that was answered.
Okay.
Okay. Sorry, there's quite a few questions. I just need to find them. Okay, so this says, I'm a special ed specialist, and I'm wondering how can I connect a parent to task or an advocate? Are advocates free for parents with students with IEPs?
You could always contact us. Our contact information, Deanna can also share in the chat. And when you contact us, you will be connected to a family support specialist that can assist you with whatever questions you may have in assisting the family that you're working with.
And there isn't a charge for our services.
Yes, they're all.
Except there may be a charge for like a Camp Techie, which is a technology program. But as far as getting assistance from a family support specialist, all of our family support specialist services, webinars, IEP consultations, all of those services are free.
So yeah, whether you're a parent, a professional, anyone can contact us.
Yeah. Youth, we invite youth to contact us as well. So
All right, so the next is who monitors section 504 in the district level?
They have a 504 coordinator. At that level. And they can contact this person by calling perhaps the school principal.
Sometimes too, if it's a district-wide, if the 504 coordinator works at the district level too, then maybe calling the district office is another way to locate the coordinator as well.
A moment. The next question is the 504 the same as other health impairment problems?
Are you in terms of eligibility or in terms, can you add to that question? Unless Elias or Anna, do you want to go ahead and answer the question? Or?
There are some students that can go into the 504, but like for instance, ADHD, that's a 504, but if it's severe, and then they can place the child in the IEP under other health impairment. So if the disability is severe, they can place the student in the IEP under other health impairment.
And sorry, just to clarify, they did clarify it was with regards to eligibility.
Okay, yeah. So I just want to add to what Elias said. So eligibility for special education is determined by the outcome of an assessment, right? And so you have to meet, and then there are 14 categories within special education that that a student can qualify under. And those categories have very specific guidelines for eligibility. So if a student, the eligibility determination isn't made because the child has a medical diagnosis or because they have a mild or moderate or severe, they're impacted that way. We want to look at how does this child's disability impact their access to education. Are they able to access their education? And if they aren't, then do they require special education services in order for them to be able to benefit from their education? And so a child who, like Elias said, a child who has ADHD may also qualify. I mean, they might qualify for Section 504 rather than an IEP only because of their educational needs. Maybe their needs can be met under a 504, their educational needs. So other health impairment is a special education eligibility category that some students who have ADHD may qualify under if they meet those criteria. But they can also, like Leah said, they may qualify instead under Section 504. So it really depends on the outcome of the assessment and what, does that assessment, how does that, let me start over. Does the outcome of the assessment indicate that the child meets the special education criteria under other health impairment? Or would the child be better served receiving services under 504? So I don't know if that answered your question or not, but yes, they can qualify under either or, but it's based on the outcome of the assessment.
Thank you. So next question. Sorry. Just a moment. So when a person with a disability applies for a job, how can one make sure he or she is not being discriminated from hiring when applicant feels he or she is qualified for the job?
Well, um, they cannot test the person to see if that person has a disability. That's discrimination. The only way that what they should do is if a person, for instance, wants to be a mechanic and goes to a shop and applies for a position, they can only test him to see if he knows about cars or buses or machinery, that he knows what he's applying for, the job that he's applying. That's all he can or she can be tested. And there's an example that this person went, applied for a position at a hospital for a financial evaluator. And they asked him if he had a disability, and he said yes, diabetes. He's a diabetic. So they send him to the doctor right there at the hospital, and they tested him. Now that was a violation, but a lot of time people don't know the law, and so they never file a complaint. But they are not supposed to discriminate. And if the person qualifies for the position, then there should be no reason why they should not hire that person. And if they don't hire the person, that might be opening for the person to file a complaint. Do you have anything to add on that, Paula?
Well, I'm not sure. It seems like we're having difficulty with our sound. Okay, there. I think that's better. You know, I think discrimination is one of those difficult things that they're hard to prove sometimes. So how do we know if the person truly is being discriminated against, or maybe if they truly are not, or if there may be somebody who is better qualified for the position? You know, I think as a person who has a disability myself, I'm visually impaired. I use Braille and I travel with a guide dog. And so I know when I've gone on interviews, I don't have a hidden disability. My disability is very much out there. Everybody can tell that I have a disability. The second I try to go sit in a seat that isn't there, or you know, I walk into a door or whatever, they're going to see that I definitely need some accommodations, and I definitely need some assistive technology. But how do I know if I'm being discriminated against, you know, because of my disability? I don't know sometimes. Now, if they're overt in their discrimination, I will say this, I applied for a job one time, and I got a letter back. And now this is true discrimination. They said, we don't hire people with visual disabilities. Okay, that's pretty blatant, right? When you get that in writing, that is a blatant discriminatory thing to do, and employers cannot do that. But what if I went into a job interview and I wasn't the most qualified candidate? Maybe they didn't choose me, but they might have chosen. They might not. Oh, you know, they might have passed over me for a better candidate. So I think that's a tough question to prove. I think a tough thing to know if you're being discriminated against or not, unless they ask you to do something that the other candidates are not asked to do. For instance, like Aaliyah said, taking a test at the hospital, or, you know, if they didn't make any of their other candidates do that and they make you do it, that is discriminatory. So if you're treated as our other applicants, and you're not asked about your disability, then you know, we have to take everything into consideration. So I don't know if that answered your question, but as a person with a disability who, you know, has gone through, I've been through a lot of interviews, and there are times where you may feel that they're being a little bit prejudiced against you. You know, I tend not to tell them that I have a visual disability until they see me walk into the room for the interview, unless I actually need an accommodation, because I don't want that to skew the interviewer's thinking. But the second they meet me, they're going to know. So I think it's different for people who might have a hidden disability.
Okay. The next question says, what if we don't agree with the school's evaluation? What can we do as a parent?
Well, the parent, there's always the option of requesting a IEE, Educational Independent Evaluation, paid by the school district, of course.
So yeah, go ahead. I'm sorry, Elias, go ahead. Yes. Okay. Yes, so you can, like Elias is saying, I think we're having some sound issues, but like Elias was saying, if you disagree with the outcome of an assessment, you can write to the district or to the psychologist and let them know that you disagree with the outcome of the assessment, and you can request an independent educational evaluation. Now, the district can say no. They don't have to do it just because you ask for it. Okay, it's like anything else. They have the option to say no. And if they say no, then they should send you a prior written notice and explain why, you know, why they made their decision. If they say yes, then they will send a list of providers, and you can also provide a list of providers, and you will compromise and work together to come up with somebody that you agree on together. And then that person will complete the assessment. And so I just another note there that there are not timelines, they're not assessment timelines. If the district agrees to do an independent educational evaluation, there's not a timeline like there is when the district is doing the initial assessment or doing their assessments. So I just don't want you to wait around, you know, thinking that they have to follow a certain timeline. They need to be the IEE, or the independent education evaluation, needs to be completed in a reasonable amount of time. So we could say that, you know, maybe a reasonable amount of time might be following the assessment timeline, but that isn't written anywhere that they have to follow that timeline. And then if you do get an independent education evaluation, the district needs to consider the results of that evaluation, but they're not obligated to implement all the recommendations of the IEE. And so parents, if that happens, then the parents have the option to appeal the decision, and then the district can file for due process or the parent can file for due process, or they can try to resolve the difference through alternative dispute resolution. So that's how the whole scenario would unfold if you disagree with the outcome of district's assessment, and kind of the ramifications of, you know, getting an independent education evaluation and how that would unfold.
Also, if I may add, the parents should ask the psychologist, the independent evaluation psychologist, if they would attend the IEP meeting and explain their recommendations and the services that they are recommending. If they leave it up to the parent is going to have a hard time explaining. So it's good to try and secure the psychologist to attend the IEP meeting with you.
Okay, the next question says, what if a child has an IEP and the school made evaluations that resulted to exit out the student from special education, but the parents don't agree to it?
Well, and then I again would suggest independent educational evaluation.
So if also too, to add to that, if a parent doesn't agree, with exiting the student from special education, then again, you're not going to sign a document that you don't agree with, right? So if you disagree with that, then you don't need to sign that document. Now, if you would, it eventually one party or the other may want to appeal the decision. And so you may need to pursue either alternative dispute resolution, which is a very informal way to try to settle a dispute or a disagreement, or you might go to due process. But like Aaliyah said, if you disagree with the outcome of the assessment that is, that the district is using to try to exit the student from special education services, then you can request an independent education evaluation. The district can say no. So then your option would be, you can get your own IEE. And then if you do decide that you want to appeal the decision, then you can use the private IEE or independent educational evaluation. If it's different than the district's exit or the assessment that they're using to determine that the student no longer needs special ed, you could use it to compare the two, and then maybe get a settlement agreement or get a decision made by the administrative law judge at due process. So there's some options. You don't have to automatically sign the IEP if you disagree with the district exiting the student. If you get to that point, TASC would be happy to go over the documents with you and talk to you about your options.
It's very important that parents, they need to understand the evaluation report. And if they don't understand it, they should seek someone out that does understand the evaluation report so that they can assist the parents. The evaluation should tell you everything. If the child continues to need IEP services or not. Now, the child really has to be doing real good to be exited out of the IEP program. And if the parents are not sure, they should get someone qualified to help them.
Okay. The next question says, student with IEP on a zone transfer was dropped from school to home due to non-attendance. I thought there was a procedure such as a meeting that would need to take place before a school site could drop a student with an IEP. Curious about the process and rights and how the apply to a student not attend their home school but are still within home school district.
I didn't get that.
Okay, so so Deanna, again, so the student they attend the homeschool district.
Why don't I read it again, Paula? Because
Okay.
So it says a student with an IEP on a zone transfer was dropped from school to homeschool due to non-attendance. I thought there was a procedure such as a meeting that would need to take place before a school site could drop a student with an IEP. Curious about the process and rights and how, I'm going to say, to apply to a student not attending their home school, but still within home school district.
Okay, thank you. So so my question is, who placed the child in the other school? Not the school of residence, but it sounds like, so the student was placed in a school within the district that's not their home school. So did the parent place them there, or did the IEP team place the student there? So there's going to be, it depends on who placed the student there, as to what the what the districts are, what should happen. So can you get that? Whoever
It
asked
says
that question?
parent.
Okay, so parent changed the placement, not the IEP team. So if the parent placed the student and the district, the school that is not the home school says that, for whatever reason, we don't have room, or the student isn't showing up, so, we're going to drop this student, then they can ask the student to return to their home school. The home school is required. Now, if the home school, if the IEP team placed the student, that's different. Then the IEP team would have to meet to before that placement could be changed. But if the parent placed the student in that school, then the school does, the school can ask the student to return to their school of residence, and they don't really need to hold a meeting or anything.
Okay, so let me move on to the next question. Sorry about that. Okay. Which is considered the most recent IEP? The last one agreed to and signed, or the very last IEP that wasn't agreed to and did not sign?
It's okay, I'll go ahead. It's the last signed IEP. Okay, so whichever one the parent and the district signed together, the parent's signature has to be on it. And without the parent's signature, it cannot be implemented. So it's the last signed IEP.
Okay. Next question says, IDEA or 504, which program provides more services to a child in elementary school?
It really depends. Section 504 is Elias taught us, provides educational rights for students who qualify under that plan or under that law, and it provides for your appropriate public education. It provides all of those same rights or provisions that students who have an IEP get. Now, it depends on what kinds of services are written into the 504 or the IEP. It depends on what kind of placements are written into the 504 or the IEP. So it really, I guess the answer is it depends. Now, one thing that separates the two programs is that special education kids who have an IEP and receive special education services, the federal government provides funding to school districts to educate students and provide them with special education services. Where students who have 504 plans, the district does not receive special funds to provide 504 services to those students. So typically kids who have a 504, what we see when we review the documents, we see a lot of accommodations that are written into those plans. We don't see a lot of related services and direct services. That doesn't mean they can't contain them, but we don't see that typically. We see mostly accommodations that are written into the plan. Maybe some assistive technology in the form of apps or that type of thing. So what can be written in and what are written in are two different things. And so it depends on what the child needs. It's based on the assessments and what is actually written in the plan. Practically, what do we see? We see that kids who have an IEP, we see that IEP documents tend to include a lot more services. The placements are specialized, a little bit more specialized. So we see a lot more, a bigger and more robust document than we see for a 504 plan. Practically speaking.
What's the difference between an FBA and ABA assessment?
FBA.
So yeah, so the functional behavior assessment is the assessment that's required under the Individuals with Disabilities Education Act. And that's to determine what's triggering the student's behavior. an ABA, that is a procedure or technique that's used to manage a student's behavior, and districts are not necessarily required to provide an ABA assessment. That's more of a technique or that's used to address or to help a student who's experiencing behavioral challenges.
Yes, and if I may add, the FBA, they need to do an assessment and provide the student with positive interventions to remove the one state they discovered the child's behavior issues, to remove that behavior with positive interventions.
Yeah.
And that's what's good about the FBA.
Yeah, so they implement a positive behavior intervention plan, right, based on the outcome of the FBA. Yeah.
And when is it appropriate to ask for an FBA at the IEP?
Well, you don't have, go ahead.
No, it's okay.
You don't have to wait for the IEP meeting to request an FBA. You can just write a letter to the Director of Special Education requesting an FBA because of the child's behavior. And you can, if there's any notes or report cards or anything that states the child's behavior in class, and then the parent can use that as the reason that they're requesting an FBA.
Yes, and oftentimes there's a communication log that, to add to what Elias is saying, there's a communication log that may go home between the teacher and the parent, or the aide may send notes related to the child's behavior, or maybe the child is being suspended, for the same type of behavior. Those are indicators that an FBA might be warranted, things like that.
And does it have to be a negative or aggressive behavior to ask for an FBA?
Not necessarily. It could be a behavior of resistance. Maybe the student is very resistant to a certain activity or to transition, or maybe the student has other kind of more mild behaviors. It doesn't necessarily have to be a destructive or aggressive behavior. Anything that is impeding that child's ability to receive educational benefit, or if that behavior is getting in the way of others being able to receive benefit from their education. And if that behavior, if we need to try to redirect the child or teach them other behavioral skills, and we want to find out, what's causing this child to behave in a certain way? What is the antecedent to that behavior? What's triggering this child's reluctance? Is there something in the environment, or is there something else going on? That's when the parent can ask for the FBA.
The next question says, what if the school IEP team is prolonging setting up an IEP meeting because they claim they need updated assessments, but claim they must be in person? However, during COVID, schools are not providing in-person assessments.
Right.
So right now, like we said before, the district needs, nothing has said that the districts don't have to follow the federal or state timelines. So there was, for a very brief time, there was a Senate Bill 117 that in California only, so the federal law was still in place, but in California only, from March 17th, 2020 to July 1st, so June through June 30th of 2020, the SB 117 said that school districts did not have to provide parents with an assessment plan within the 15 calendar days per the Ed Code. And so, but as of July 1st, that law was made inoperative. So as of July 1st, districts are required, whether we have hybrid, in-person, distance learning. Nothing in that we're aware of anyway prohibits a district from complying with the federal and state guidelines, and none of those timelines have been waived, that we're aware of at this time. So.
Sorry, I was muted. Sorry
That's
about
okay.
that. The next question says, my child has an IEP for a special learning disability and speech and language impairment. He was recently evaluated from an outside agency for autism spectrum, and I want the school to include his new disability to the IEP. What can I do? I provided to the school the agency's evaluation and results for autism.
Well, I do believe that the school district would have to do their evaluation under autism. They do have the child in speech and language, and I think you mentioned learning disability. So
Yeah.
they don't have to accept outside evaluations. They usually like to do their own. Has the parent requested from the school district an autism evaluation?
So yeah, and so I think they would need to request maybe a psychoeducational assessment, or maybe some other. So when you, let me back up. So when you receive a medical diagnosis, that's a medical diagnosis, but the district doesn't need to use a medical diagnosis to qualify a student under a category. The district, like Leah said, the district needs to do their own assessment to determine if the child needs special education to receive benefit. And so then you could request, if the district hasn't completed a psychoeducational assessment, or maybe if it depends on how the student is experiencing autism. Do they have occupational therapy concerns, physical therapy concerns? It really depends on what the need is. Do they have behavioral concerns? Do they have social pragmatic concerns where they're not able to socialize with their peers? That type of thing. So the way to get the district to assess would be to ask to let the district know that you have a new medical diagnosis, and then to let them know that you'd like to have your child assessed to determine if there are other areas of need related to the new disability. Okay, because the district needs to assess in all areas a suspected disability. So if you feel that the diagnosis of autism is resulting in other types of manifestations, like I said, occupational concerns or physical therapy concerns or speech concerns, then you would ask the district to do assessments in those areas. And then the district, and do another psychoeducational assessment. Then the district can determine if the child meets the criteria under autism to qualify, and needs those services to get to receive the services that they require to address their educational needs. So I just want to be really clear that the medical diagnosis isn't what obligates the district. It's the outcome of the educational assessment that would then require the district to implement the services that the child needs based on their educational assessment.
I think that's all for the questions.
Okay.
Anyone else, I guess? Those were all the ones that people had put in. I don't know if anyone else has any other questions.
Okay. Those were great questions, and we appreciate that. And like Leas and Anna have said, if you want to speak with a family support specialist, you can either email us or call us at the contact info that's in chat, and you'll be connected with a family support specialist. And we are working from home, so the number may be blocked, or it will be blocked, I should say. So if you're not able to pick up, then the family support specialist will let you know what time frame they'll be calling you back, so that you have an idea. You know, if you get a call from a blocked number during that time frame, there's a really good chance that that's going to be task calling you back.
And Paula, if I could add something.
Yes.
This is Deanna. I just wanted to thank our interpreter, Kara. Thank you so much. Everyone's worried about you. So thank you so much. I know it was a long presentation, but we appreciate you.
Thank you very, very much.
Yes, thank you.
Thank you everyone for joining us on this webinar and being part of this webinar.
Thank you. Thank you, Kara. Paula,
Yes.
there is a question. They're asking when the recording will be made available on YouTube.
It's usually up within 2 to 3 days. It depends on how quickly our IT person can get that out. But he typically gets it up or to me within 2 to 3 days. So we'll put it up there. I can't promise because I'm not the one who does it, but I'll say 2 to 3 days. It should be on our YouTube page.
The next question is, will it be possible to add captions?
You know, we don't have that ability right now, but I am looking into that. And I apologize. As a person who requires a lot of accommodations, I apologize that we don't have that one in place, but we're working on it.